Good afternoon, everyone, and welcome to the luncheon for the 12th ITA-IEL-ICC Joint Conference on International Energy Arbitration here in Houston. I would like to thank very much to each of you for making the journey to Houston to be here with us. I'm Krina Baltag. I'm a professor in international arbitration at Stockholm University, and I'm honored to serve as the vice chair of the ITA Academic Council, as well as the chair of the Preserving Perspectives project. I would also like to acknowledge Victoria Sahani, the chair of the ITA Academic Council, who could not be here with us today. I would like to thank the chair of the ITA, Tom Sikora, and to the ITA staff, led by TL Kabic, with the assistance of Daria Shirakova, for helping us to bring this luncheon interview to fruition. I would also like to thank ITA's partners in organizing today's conference, the Institute for Energy Law of the Center for American and International Law, and the ICC International Court of Arbitration, as well as the co-chairs of the conference and the luncheon sponsors. The ITA Academic Council's interview project, Preserving Perspectives, International Arbitrators in Their Own Words, is important and wholly unique among projects hosted by various international arbitration organizations worldwide, in that we interview prominent international arbitrators and record the stories of their lives and careers as they themselves tell it. Afterward, the videos of these interviews are memorialized forever on the ITA website, so that future generations of international arbitration practitioners can watch and learn from them. I am pleased to introduce today's interview of Doak Bishop by Tom Sikora, the chair of ITA and senior counsel, ExxonMobil Corporation. And we are tremendously grateful to have them here today and be part of this project, and for agreeing to serve as an interviewee and interviewer. We very much look forward to their conversation, and without further ado, the Academic Council of the Institute for Transnational Arbitration is very pleased to present our Preserving Perspectives project interview of Doak Bishop, interviewed by Tom Sikora.
Thank you very much, Krina. I am delighted to be here with my friend Doak Bishop, and I'm so grateful to him for agreeing to take part in our oral history project. Who is Doak Bishop? I think for 99% of the people in this room, no introduction is necessary, but perhaps for the youngest practitioners, Doak Bishop is one of the absolutely preeminent practitioners of international arbitration, and especially international investment arbitration in the world. He also has a deep connection to the ITA. He was asked by our founder, Pat Murphy, to get involved very early on in the 1980s, and he was one of the major players behind the development of the ITA. He was a former chair of the ITA. He's, of course, a partner and the founder of the King and Spalding International Arbitration practice, which has grown greatly to great prominence under his leadership. And to many of us of this generation, he is the person responsible for introducing us to investor-state arbitration, and responsible in part for the great growth of that practice in the United States. But this is supposed to be his interview, and we want to hear from him in his own words. So perhaps we should start at the very beginning. Doak, tell us, where were you born and where did you grow up?
I was born north of Dallas in Denison, Texas, the same city that Sully Sullenberger came from, who landed the plane on the Hudson. He was my classmate. So I was born and raised in Denison.
And I think one of the remarkable things about Denison is that there is a very large Air Force base, the Perrin Air Force Base nearby.
There was, yes.
There was. But you had a very special connection with that base. Your father worked at the base.
Yeah.
And I think my sense is that part of that introduced you for the first time in a very interesting way to the international world beyond Texas and the United States. Can you talk to us about that a little bit?
Yeah, I'd say that's true because my father worked there, and on weekends and holidays, he would often bring visiting airmen from other countries home to have dinner with us or spend the weekend, and had a chance to spend time with airmen from Germany, from England, from Turkey, from other countries, and it was a broadening experience. It was an opportunity to get to know people from other countries in our little isolated area of the world, and so I think it was a very internationalized experience to that extent. And I remember that one of the airmen from Germany helped me prepare my science project one year, and when I was in junior high, I think.
With great German precision,
With
right?
great German precision. It wasn't my precision, it was his.
Your parents, like mine actually, were not lawyers. They had nothing to do with the law. Your relatives had also nothing to do with the law. So how is it that you decided to become a lawyer? What were the motivations, and when did you decide to become a lawyer?
Well, I would say that partly from watching television shows about trial lawyers, which were all criminal trial lawyers back in those days. I wanted to be an articulate person, and these were role models, and I didn't think of myself as an articulate person back in those days. And one day my grandfather told me I should be a corporate lawyer. I didn't know what a corporate lawyer was, but I remembered that. But then in the 8th grade, I remember I decided to be a lawyer, and I never wavered or changed after that.
And how fortunate we are that you haven't wavered. Moving on, you started your college career at Tulane, but then you transferred over to SMU.
Yeah.
But SMU gave you an exposure to international law, ironically. Can you tell us about that?
Oh yeah. I took a political science course at SMU in international law, taught by Aunt Tomasz. She wrote a lot of books on international law with her husband Frank, and they were well known in the international law field. He taught in the law school, she taught in political science. It was a great course. I found it extremely interesting, and I happened to sit next to a woman in the class who became my wife. That's how we met, as a matter of fact.
And I understand you got the 2 highest grades.
We did.
In that class.
I'm not sure who copied from whom, but yes.
Doak then attended University of Texas Law School, and one interesting thing about your law school career is that you and your partner won the Best Brief Award in the freshman moot court competition. How did that happen?
Well, it was as I remember, we had a problem based on the Bakke affirmative action case that was going on back at that time. So it was a 5th and 14th Amendment constitutional issue. And nobody in the class knew how to argue those issues back as freshmen. And I just remember that we researched it, and we wrote our brief, and then 2 days before it was due, we kept going back to the library looking for more, and found a reference to this other article that was right on point. The library didn't have it, but they sent us to the admissions office, where we found the article which set out the arguments in a way that constitutional lawyers know how to argue them. And so we threw away our brief, and for the next 48 hours, we completely rewrote it word for word. I did not sleep for 48 hours and got it to the typist just in time. And we won 5 out of the 6 votes for first place. So that's how that happened.
And incidentally, not sleeping for 2 hours, for 2 nights is perfect preparation for what we call final arguments or closing arguments.
Yes, we've done that before.
So in 1976, you graduated from UT Law School, and you chose to come down to Houston to join Fulbright. Why did you choose to join Fulbright at that point?
Well, Fulbright at that point was the fourth largest law firm in the world. Houston had 3 of the 10 largest firms in the world. Fulbright had a very active trial practice, and they could get me to trial faster than any other place, at least as I saw it. Plus, they had an excellent trial training program. And I wanted that opportunity to go through the trial training program and to get to trial quickly, to get the trial skills. Plus, in handling small cases, they're your cases. You get to be the lead lawyer. You get to make all the strategic decisions. And so I went there with the agreement that they'd put me on their 2 most active dockets, trying lots of workers' comp cases, insurance cases, and that I would ultimately go to medical malpractice, which I never did. But I got a chance over the first 3 years or so to try a lot of small lawsuits and get the skills of being up in front of a judge and jury.
In 1979, I understand largely because inflation that was raging at that point in the United States, Doak decided to move the family to Amarillo and practiced with the Wittenberg law firm for 3 years.
Well, Doak didn't decide. Deborah and Doak decided, and Deborah was from that general area, so Deborah decided, and I said, okay.
But you got a phone call from a high school classmate who was the former general counsel of a very important company in Dallas, which took you to Hughes & Lewis. Can you tell us about that?
Yeah, David Bryant. I grew up with David. David and Sully and I were all 3 in the same class. He went to Harvard Law School as an editor in the Law Review there, and he came back to Dallas, to Hughes & Lewis. He became the managing partner, and he called me when I was in Amarillo and said, do you want to come back to Dallas? And I said, yeah. At that point, I was ready to do that, and so that's how I got back to Hughes & Lewis.
What was your practice at Hughes & Lewis?
Well, I had done a lot of products liability cases over the years, but at Hughes & Lewis, I was representing Ross Perot's company, Electronic Data Systems, a lot, representing them against hospitals and the federal government, HHS, and various class actions and things involving data processing. Around the mid-'80s, they asked me to be the point person for dealing with M-Corp. Again, at that time in the mid-'80s.
A bank holding company.
Yeah, at that time, Texas had 3 of the 10 largest bank holding companies in the country. That doesn't exist today, but they asked me to be the point person for M-Corp, and so I did a lot of bank holding company litigation for a while. Lenders' liability, as oil and gas prices dropped from the mid to late 80s, real estate prices dropped, and the economy of Texas went down, and the banks in Texas went down, and all got taken over. But I was doing a lot of lender liability litigation for M-Corp back in that period, and was involved in the bankruptcy of M-Corp. So I was doing a lot of EDS, a lot of M-Corp litigation in those days.
So what's interesting here is that, we're in the 1980s in Texas. There was no such thing as international arbitration in Texas. There's actually really probably no such thing as international litigation in Texas at that point. How did you get interested in international litigation?
Well, that probably goes back a little bit. I always wanted to be a trial lawyer, a litigator. But when I was in high school, I read something about this thing called international law, and possibly because of my experiences just meeting people from Perrin Air Force Base, I developed a strong secondary interest in that. Trial law first, but international law second. I didn't think there was any way you could combine those two. But in the late 70s, early 80s, starting I guess when I was at Fulbright, I'd go down and peruse the library sometimes, and I found this thing called the ITA Yearbook of International Arbitration and started reading some things in it, and I thought that was interesting. I did not see any possible way of getting involved in it. But I started writing about international litigation around 1980. And over the course of the next 10 years, I wrote a lot of articles about that subject. And because I needed a hook as to how this was going to be different, I used Texas as the hook. So I was talking about international litigation in Texas. I got on the Supreme Court Rules Advisory Committee and rewrote the rules of procedure with respect to cases that involve foreign parties and international parties, enforcing judgments, proving up foreign law. And so I got involved in those types of cases also in the 1980s. And so I was lecturing on that topic, writing on that topic, involved with the rules committees on that topic.
And I take it as a result of those articles and those lectures, one day you were contacted by someone named Pat Murphy, who had just created something called the Institute for Transnational Arbitration. And tell me about, I understand he asked you out to lunch and wanted you to get involved. Tell me about that.
Yeah, it's a very important point in my career. I was doing just smatterings of the international litigation. But yeah, sometime around 88 or 89, there's two guys who'd put together ITA, Pat Murphy and Bill Owen. Some people here knew Pat. Many of you here probably didn't know Bill very well. But Bill had been the general counsel of Saudi Aramco back in the 40s, 50s, 60s, and then become an international arbitrator and was the international energy arbitrator in the world. And he was from the University of Texas and living here. And as a matter of fact, he recommended me for my very first international arbitrations. But I got involved in the ITA through those two guys, went to lunch with Pat. He asked me to serve on the board. And so from about 1990 until maybe today, at least in some capacity, I've been involved with ITA.
And I take it
it's been a very important influence in my career.
You are the person who wrote the early mocks for the early workshops.
Yeah, I think I did. I think for about 10 years I wrote the scripts for the mocks, and I participated in a lot of the mocks. And in those early days, in the early 90s, we were to a certain extent playing them for fun, but also trying to educate people. And they educated me. They gave me an opportunity. Those were my first international arbitrations. I had started being an arbitrator for AAA in the early 80s. And matter of fact, my first arbitration was as an arbitrator, not as a counsel. So I had some background in domestic arbitration. But yeah, the ITA mocks were my first exposure to international arbitration. Then Bill Owen recommended me for a couple of relatively small cases. And I got in those, and then it built up over a period of time.
And around 1997, you wrote a very important article about international petroleum disputes and the development of Lex Petrolea, which gets published by Jan Paulsen in the LCI journal.
You're getting two of them confused, but yeah, I decided that my entry here, I'd been doing oil and gas litigation too since the mid-'80s for Valero, doing a lot of take-or-pay cases. That was another part of my practice. And being in Texas, I decided that if you're going to go into international arbitration, it's got to relate to the energy industry. And so I decided I was going to do a survey of all the published articles on international arbitration of energy disputes. And so I went out and surveyed it. There were about 30 some odd cases, and categorized everything, broke them down, and I wrote the article on Lex Petrolia. And I was trying to figure out where to get it published. And Albert Jan Vandenberg suggested
ITA yearbook, yeah.
suggested publishing it in the ITA yearbook, and told me that they did not publish articles. They hadn't published articles in 10 years or so, but they published that in the yearbook. And so that got some attention. And then the same year, I wrote an article with Lucy Reed, whom I'd met at the ITA the year before, and on selecting party-appointed arbitrators, disqualifying party-appointed arbitrators, which I think was an important article because we categorized certain scenarios into what ultimately became red, orange, and green in the IBA guidelines. I think it was used as as the basis for the IBA guidelines, although they never gave us credit for it.
And this is the article that Jan Paulson picked up.
Yeah, and this is the article
published.
that Lucy brought it to the attention of Jan Paulson, and he put it at the beginning of the quay for the LCIA publication, and it was published in the next quarter.
There was one other important thing that was happening at that point, which is you started a group that met regularly to talk about international arbitration with a lot of in-house counsel.
I did. Well, I identified who would be the international counsel at 15 or 20 of the largest companies in Texas. And I contacted them and asked them if they were interested in a luncheon seminars once every other month. And I got 15 or 20 of them interested, and we would have a luncheon one day in Dallas and the next day in Houston, which I paid for. And we would, I'd provide a little, very small booklet of key articles and materials on those particular subject, have a particular theme for each one of them, and we'd have a discussion about some particular problem, discovery, or choice of law in international arbitration. So I got to know a lot of the top players in the corporations in Texas back in those days.
Including our predecessor, Gene and mine, Ed Lynch, who was at Exxon Company.
That's right. Ed was there every one.
And in December 1998, that sort of the lunch group really pays off because you get a call from a small company called Mobil, who's interested in doing something called an ICSID arbitration.
Yeah, I'm not sure whether they knew it was an ICSID arbitration when they first called, but yes, I think it was December 1998, we filed an ICSID arbitration for Mobil against Argentina that involved provincial tax issues, as I remember. It got resolved very quickly. It didn't go very far, but that was the first one that I was involved with. And I do remember having no template whatsoever for preparing a request for arbitration at ICSID, and just going through the rules and figuring out exactly what I needed to put in there. And it became the template for just everything we did thereafter.
But a key development is that you were able to write about this Mobil case in the ITA News and Notes.
Yeah, well, I think I wrote just one or two paragraphs in the ITA Notes entitled "What's Going On in Argentina," which got picked up by a lawyer at Enron at the time who called me about a Enron case against Argentina. It's led to the second case.
So in 2000,
Yep.
you decided to join King & Spalding in Houston, and King & Spalding wanted you to build a team to do international arbitration.
Yeah, they did. I was doing international arbitration, but I was also had a docket of energy litigation back at that time for a few energy companies. And I had been trying to determine, can I transition to a full-time international arbitration practice? And so I started that process in 2000. The firm was supportive and wanted me to do that. And so about 2001, I was doing more and more international arbitrations. And then in January 2002, Argentina helped me out substantially in building a full-time arbitration practice.
I wanted to mention, I think around 2000, 2001, you met John Aiel, our friend John, who was at that point the general counsel of Azurix, the international water subsidiary of Enron, which again had a problem in Argentina. And so you wound up filing a case against Argentina for Azurix.
That's right. That may have been the third, but yeah, I think we had the Mobil, the Enron, the Azurix, which became a very interesting case. It had to do with the water concession and the contract, which included tariffs and such, putting them into a contractual form so they couldn't change them, but they went and changed them anyway. So that was a fascinating case and wound up with a significant award.
And here an important event intervenes in practically all of our lives. I think it was December 21st of 2001, President Fernando de la Rúa of Argentina flees the Casa Rosada in a helicopter. There's a succession of several presidents within literally, I think, 4 or 5 days. And new President Dualde on January the 6th decides to pass, with the Congress's help, an economic emergency law, and pacifies all the contracts in Argentina. Argentina had been pegged to the dollar. The exchange rate collapses. And even though now really the exchange rate is 4 pesos to the dollar, President Dualde decides they're going to artificially pacify all the contracts at $1 to 1 new peso, wiping out most energy investors in Argentina. And so a series of cases begin, one of which is in late 2002, early 2003. Doak was approached to file the El Paso Energy International case against Argentina, which is how our friendship turned into working together for the next 10 years. But what I thought was really fascinating at that point, Doak, was in the early 2000s, before there had only been a handful of investor state cases, maybe 1 or 2 a year, until about that time. And very few cases had been decided on the merits at that point. The new cases that were just filed hadn't been yet completely adjudicated. And so what was it like in the early 2000s to file an investor state case?
Well, I mean, during that period, there wasn't much law on several issues, jurisdictional issues, quantum issues. And so the kind of case law, relatively developed case law we have today simply didn't exist. You had at most 1 or 2 cases on an issue. We didn't know which companies in a corporate chain we could certainly get jurisdiction over when we file. Could we get jurisdiction over the ultimate parent company or an intermediate company in the chain? So there was a real issue jurisdictionally about who could bring the claim. There was an issue about if you brought a case for a company higher in the corporate chain, what kind of damages would they be entitled to? How would you calculate damages for them? So those were a couple of the types of issues that there simply wasn't any law on in those days. And so we were having to figure it out as we went. The expropriation issue, what constitutes a creeping expropriation, wasn't anywhere close to being settled. Issues like fair and equitable treatment, nobody knew what fair and equitable treatment meant. We were literally making it up, looking at what other people were doing, and we were making up definitions, I think, essentially trying to understand it, see what was out there. We kept researching and researching and researching to figure out what did these treaty drafters mean with fair and equitable treatment, and where did they take it from? And there was a lot of research on that, but very little answers to that question. And then Argentina threw a curve with this necessity defense based on a provision in the treaty. And again, we did lots of research trying to figure out what that means. And you had necessity defense and customary international law, but nobody knew what that treaty provision meant. And so again, we had to basically figure out how to argue that from scratch.
The U.S. Argentina bid had a measures not precluded provision, which was the grounds of the defense of necessity that later caused a lot of trouble for some of these cases. I can't resist telling one story about this case, which is the problems were manifold. It was not just an issue of not knowing what the law is. Opposing counsel was also sort of grappling their way through a new system. Our client was the chief financial officer of El Paso Energy International, and we had a jurisdictional hearing in May of 2005 in Paris. And we didn't know what to expect. One thing I drilled into him is, listen to the question, only answer the question posed. He was a very nice, helpful individual. We didn't want him to help the other side by pontificating about the investments. And so he was being cross-examined by a young Argentine woman lawyer, whose name we will withhold. And the first question starts and continues and continues and continues. And I'm looking at our client, and he's turning bright red because he's listening so hard. He wants to know what the question is and how to answer the question that's posed. And probably literally 5 minutes into the question, the Argentine Procurador de la Tesoro de la Nación lawyer stops. And we don't know what the question is. And I was worried that he was going to get a heart attack at that point because he was bright red. And he finally asks, is there a question? Anyway, that was a hilarious experience. We found out that it was the very first cross-examination she had done in her life, and just didn't realize that you don't lecture at the witness, you ask the witness a question. The El Paso and the Enron, the Azurix cases turned out to be followed by many other cases. I think you had something on the order of 20 cases against Argentina.
Yeah, I think I ultimately filed approximately 20 cases against Argentina. It may have been 19, but it was right around that time.
So I'm going to throw a question at you, which I hadn't thought of before, but I had one case against Argentina.
Wait a minute, this isn't in my notes. Goodness
it was
gracious.
overwhelming. It was crazy. I mean, we were blocking and tackling, and there was not enough hours in the day. He had 20. How did you cope? How did you survive?
Oh, with 20 cases? Well, I turned down other cases. I remember being offered a satellite arbitration back in those days, which would have been a great case, and but they wanted me to work on it full time. But I had umpteen cases against Argentina going, and I told them I couldn't do it. So I wound up having to turn down some wonderful cases. But I already had these cases.
And you had a great team.
I had a great team.
So many of the lawyers in this country who are leaders in international investment arbitration were trained under you in the 2000s in these cases.
Well, there are a whole bunch of them in this room. Will Russell, Sasha, Sylvia, David, Alberto, Wade Coriel.
Craig Miles.
Craig Miles was one of the first. Roberto Harry Luzzi came. So yeah, We did build a great team, and
Did you notice that the prior panel to this lunch
I noticed.
was composed entirely of King and Spalding alumni? It was not an accident. The answer is that it was such a wonderful team was needed to handle all those cases where law was very uncertain and the facts were highly complex.
I wrote down their names so I could do some recruiting after this.
So it led to a wonderful career as counsel and arbitrator. And I should mention Doak is a very sought after arbitrator, particularly in investment arbitration, particularly in energy. But in addition to being a wonderful arbitrator, he's actually a wonderful author. In addition to the articles that I mentioned and got backwards, because they're both in 1998, which is a long time ago, you've edited a large number of books initially on some really important topics. On the enforcement of judgments against sovereigns. I think that was the first book you edited that I remember in 2009. And then on the art of advocacy.
Yeah, that was the first one.
Well, it was published in 2010, but I'm sure you'll remember exactly when you
But the first one was published in 2004. This was the second edition in 2010.
But then you actually started writing your own works. And I don't want to get the order wrong, but you wrote a wonderful monograph on annulment in the ICSID system with Sylvia Marchilli.
No, Sylvia wrote that book and allowed me to put my name on it with her, which I was happy to do. It's a great book.
But the next one I think you have definitely written, because I think it is probably the book we all know best. And maybe you should tell us how you were introduced to your co-authors and how the book came about.
You're talking about foreign investment
disputes?
Yeah, well, the origin of that book goes back to the week after 9/11 when we were looking for an arbitrator in one of the cases against Argentina. I don't remember which case it was at this point, but I was on a flight to London and then to Paris literally a week after 9/11. I think they were the first flights they allowed to fly. We had more flight attendants than we had passengers on the flight. But I flew to London and I went up to Cambridge to interview James Crawford as a possible arbitrator. James, we had a great interview, great talk. He didn't feel for some reason or another that he could take an appointment. But we started talking about the fact that there was no book in this field, really. And we started talking about the possibility of doing one. And then later I suggested that maybe we ought to have another co-author. And they said, well, fine, but it's got to be somebody pretty good. And I said, well, what about Michael Reisman, whom I had met at the ITA. Donald Donovan had him as a keynote speaker at the ITA one year and introduced me to him. And I used Michael as an expert witness in some of the Argentine cases. And so with James' approval, I brought Michael into the project, and then the three of us put together the Foreign Investment Disputes book, which was, anytime you can put your name on a book with two of the best international lawyers in the world, it's going to improve your reputation. And I think that's what happened to me.
And Michael is such a gentleman and wonderful to work with. We used him as an expert witness, at least in the El Paso Energy case, and probably some others.
Yeah, that's right.
And I remember getting so frustrated because the chair of our tribunal sat on our award for 5 years, and Michael was trying to calm me down.
4 1/4.
Look, he got it just right.
It's a long time.
So one of the books you edited is on the art of advocacy, and I think that's not not an accident, because this has been an area of your interest for a long time. I believe Lucy asked you to do a keynote on this. Can you tell me what got you interested in this area and where you spoke about it, and what's the origin of the ITA program on it?
Well, yeah, I'd go back to the 1980s in trying cases. I worked with a number of jury consultants in big cases in the 1980s and had an opportunity to see behind the scenes how juries deliberated in mock trials. And I learned a lot from that. And then there were people like Donald Vinson, who's a famous jury consultant who was writing books about it. So I got very interested in that topic, as this is a way for trial lawyers to learn how to be persuasive. And I started giving speeches on it at the University of Houston and at SMU back in the late 1980s and early 1990s. So it was a subject that I was already very interested in. And then I was interested in trying to bring some of that information and knowledge to international arbitration. And so that was the genesis for at least the idea of the book of The Art of Advocacy. Which
led to, by the way, a workshop on heuristics and arbitral decision making.
Yeah, you're talking, okay, so in 2012, Lucy asked me to give a keynote here at the ITA, and I was trying to figure out what to speak about. Everybody talks about procedural issues in international arbitration. Just about every topic was procedural, and I didn't want to do that. I wanted to do something different. So I think the topic I chose was the quality of decision making in international arbitration. I dare you to find that topic anywhere in international arbitration seminars before then. But I got into heuristics and put a number of different things together. I used Daniel Kahneman's book to a certain extent, Thinking Fast and Slow, about the psychology. And the presentation was well received at the ITA.
I think it was, for our advocacy, it was life-changing in many ways. For those of you who were in the room, do you remember the slide with the chessboard, with the shadow on one of the squares? And everyone thinks that square is white, and then you remove the shadow or you move the other squares, the square is actually black. You don't see what you actually see. You see what your mind expects to see. Yeah. And even if you realize that you've been tricked, the next time you look at the chessboard with a shadow, you still see that chess piece, a block as white. You can't fix it. It's hardwired and unfixable. I think it had tremendous influence on those of us who participated in that workshop, because it really focused us on the importance of heuristics in arbitral advocacy.
Yeah, no, and after that ITA workshop, there started to be a proliferation of seminars, I think in Europe first, on this topic of heuristics and international arbitration, and there have been a number of them since then. As far as I know, that was the first one.
I can't think of Doak Bishop without remembering heuristics. So important. You've sat on many, many important tribunals.
I might add, I think Luke is here.
Yes, he is.
Luke and I are trying to work on a possible book on this topic of decision-making in international arbitration and its implications for advocacy and the psychology of persuasion, essentially.
And it's so important. We had a case where the state had a 7-year audit period. And the way we argued that case is we wanted to make sure that the state had an adequate audit period. So we didn't let the state have 30 days to audit. We didn't let them have 60 days to audit. We didn't even let them have 90 days to audit. We gave them 7 years. And at that point, the tribunal was shocked. How unreasonable was that 7 years? Because they had been anchored to 30, 60, 90 days.
By the way, there's a certain theme here. You're mentioning the books. If If you look at the books, almost all of the books I did, I have done with someone else, like Sylvia and Luke and James and Michael. I figured out early on that you can do much better work, I think, if you have alliances and if you have the very best people to work with. And I've tried to do that, tried to get co-authors who are smarter than me and that we could work together and develop books. And I think it's been a great opportunity for me.
Not only as author, but also as counsel. I remember you had phenomenally talented Argentine co-counsel in these Argentine cases.
I did.
Jose Martinez de Oz comes to mind, Guido Tawil.
Yeah.
There are a few questions that we ask all of our interviewees. Is there you moved on at some point to being a very eminent arbitrator. Is there an award, or are there a few awards that you think were particularly impactful or had the broadest influence?
You mean as an arbitrator?
As an arbitrator,
yeah. Perhaps the Vigatop versus Hungary award, where we dealt with the issue of what's the test for expropriation of an investment when there is a contract, the investor has a contract with the state or a state entity, and the state says it's just exercising its right to terminate under the contract. And in that situation, what is the test for expropriation? And I think we set it out in that award, and I think it's been used in some other cases. In the Windstream Canada case, we talked about fair and equitable treatment. And then we talked about fair and equitable treatment in another case involving the South Africa, involving the government of Lesotho.
Yeah.
Yeah, and SADC closing one of its tribunals. Yes.
Well, can you tell us a little bit about that case? Because that's an award where the tribunal is actually quite bold in protecting the rights of a claimant.
Well, I didn't think we were bold, but I think the
state did.
The Singaporean courts apparently thought we were bold. It's the only award I've ever written that's been overruled. But it was a case where SADC, the Southern Africa Development Community, had a court for handling investment cases. And they had a series of cases before them, and they closed the court. They closed the court down with cases already pending before them. And one of those cases, because there was another investment treaty, a BIT, a case was filed under the BIT against Lesotho. And so we had a chance to look at that. One of the issues was precisely, is it a violation of international law to close down an international tribunal with cases pending before it and never decide them? And so we looked at that issue. We decided that we did not have jurisdiction over the underlying expropriation claim, but that we did have jurisdiction over the more recent closing of the tribunal without providing another forum. So we held that that was a violation of international law, and I might add that the UN rapporteur for that field had written opinions saying he thought it was a violation of international law. So we decided that, and as our remedy, we told them that they should have a 3 arbitral tribunal in Mauritius because it handled a lot of African cases, and it was part of the SADC, as I remember, and that each of the 3 arbitrators had to have the same qualifications as SADC judges. So that was our remedy, but the Singaporean courts, which is where we had cited the case, disagreed with us on jurisdiction and overruled it.
You've been involved in very many cases over the years, and I'm curious, do you have any favorite cases, whether as counsel or as arbitrator?
Well, I could probably go back and talk about a number of them, but the one that comes to mind is the most recent is probably the Chevron Ecuador cases, the two denial of justice cases. There was the first denial of justice case involving claims pending before the courts of Ecuador for 11 years without a decision, commercial cases, but no decision. So we took it to a PCA award and won that case. And then the second Chevron Ecuador case, which was the Lago Agrio case, which is still going on to some extent. But we got the Track 2 award on liability. It's been completely upheld by the Supreme Court of the Netherlands now. So the defensive part of that case is completely over, but that's a magnificent award, and I think it's probably the most important denial of justice award in international law. So that would be one.
And you got to work with one of the most gifted in-house counsel ever, Andres Romero Castro.
He's extremely good. Well, I got to work with a number of people from Chevron over the years. He's one, and he's an excellent lawyer, absolutely. And then there was the case for El Paso against Argentina, where I also got to work with a very good in-house counsel.
I don't know who that was, but I remember there was 5 cases within one, which made it incredibly complicated. Mm-hmm. 2 power generation, 1 gas processing, and I think there was a pipeline and oil production. It really wasn't one case. It was a whole bunch of cases because El Paso had so many impacted investments.
Yeah. It's a great case.
Switching subjects to maybe some thoughts about international arbitration. What do you think are some of the most valuable things that arbitrators can do to control the cost and time in international arbitration proceedings?
Yeah, well, when I was first getting into international arbitration back in the 1990s, there was a movement about arbitrators being more interventionist and being more proactive to take control of the case early. If I remember the ITA meeting in 1998, which was the first one I attended, I think that was one of the themes of that particular conference. And I think that today, from talking to a number of people, including people here, there's a strong desire that international arbitrations, particularly investment cases, need to move faster. They need to be cheaper. There need to be means of moving the case along, not having the case, not having the case abused or the process abused by repeated objections to arbitrators. I think in the Conoco Venezuela case, Venezuela challenged the same arbitrator 8 times, as I remember, all of them nonsensically, but all of them overruled, but just one after another delaying the case. That's an abusive process.
You've witnessed some of the biggest changes in international arbitration since you began your career. What do you think they are, in your view?
I'm sorry.
The biggest changes in international arbitration since the beginning of your career.
The biggest changes, well, for me at least, I started in commercial arbitration, so getting into the investment arbitrations, seeing investment arbitrations grow, seeing the number of cases, the size of the cases grow, and the proliferation of the case law, developing it. So I would have to say, to a great extent, it's the development of investment arbitration, which I think has been a very important subject for international commerce because these kind of problems have been there for a long time in international transactions. And the investment arbitrations have given companies a forum to take them to a neutral decision makers to decide, get them outside of the local courts, get them outside, some cases, the contract itself. And while, you know, we can all point to this case or that case as we think they got it wrong, but on the whole, I think the system has actually worked quite well. And I think that most of the arbitrators do a good job getting to the right result. So I think that this has been a salutary development in international commerce. And I hate to see the attacks on the system, which, you know, I do think that there definitely can be a few things made better. But on the whole, I think the system is good, and I don't think it ought to be dismantled.
I will ask you three relatively difficult but quick questions that we ask all of our interviewees. What do you think
I don't answer hard questions, Tom. I just the easy questions.
What do you think is the future of international commercial arbitration?
Well, I think that there's going to be a growth in international commercial arbitrations with the transition to green energy. There's going to be trillions of dollars or hundreds of trillions of dollars of investments. There are going to be different kinds of disputes, most of them involving the same legal principles, but a lot more disputes. So I think that the future for it in terms of numbers is going to be bright. I think we're going to see more of it. I think there will also be a need, though, for moving many of those cases along more quickly than we've seen in the past to get to a decision more quickly. There may be a need for something like dispute review boards in some cases for projects to be able to move along and not get bogged down. But I think we're going to see more of those disputes, and I think that the international arbitration is going to have a bright future.
I fear that was too easy, so let's try again. What do you think is the future of international investment arbitration?
That is harder because of what we see in Europe in particular, the various attacks on the system by activist groups that have gotten some governments very much involved and interested in that. I think you sit on a UNCITRAL committee that tries to, or at least there are attempts there to defang the system. And I think, well, as far as I know, most of the radical proposals have been, I think, beaten down, but there have still been some changes along the way. There'll probably be some more changes. But as someone else has said, and I've forgotten who, the problems are there. The problems in, of dealing with sovereigns in these kinds of issues are there. They're going to continue to be there. There's going to continue to be a need for a method of resolving these kinds of disputes. We already have a culture of how to do that through what we already have, and we need to use that and extend it. So I think that the system of investment disputes is not going to go away. I think it's going to continue. It may transform to a certain extent, but unlike the last panel, I'm more optimistic, I think, about the future of investment arbitration.
All right, hardest question then. What advice would you give to law students and young professionals who are contemplating a career in international arbitration?
It's not as easy to break into today as it was 25 years ago. 25 years ago, there were relatively few firms, I would say, who were doing it, and you could identify who they were. Now, there are not 12 firms, there are 1,200 firms. I think that's a good thing. I don't think that's a bad thing, but I think it may make it a little bit more difficult because of the fragmentation in the representation and in among arbitrators. But I think that the system itself has opened up. It's opened up in terms of diversity. There are more opportunities in that respect. I would say for anyone starting out, I would say the first thing you've got to do is become a good lawyer, a good substantive lawyer. You have to have good communication skills in writing. You have to have good oral communication skills, so you need to be building those. You have to have strong skills in analyzing cases. You have to develop sound judgment in the field. So the first thing is just what you would tell any student starting out is become a good lawyer first. But also, I would say, take control of your career. That you shouldn't sit back and let your career just roll along or ramble along. You should take control of it. Decide where you want to go. What kind of lawyer you want to be, what kind of cases you want to handle, and set a strategy and a plan for how to get there. I think in writing the Lex Petrolia article back in 1998, that's exactly what I did. I decided I wanted to be in this field, and I took the first step of writing an article surveying everything that was out there on this subject, and it got noticed. So, write, get out there and speak, put yourself out, but make sure that when you do, that every time you give a speech, everything you write, if it's going to be noticed at all, they're going to take note of, is this well done? Is this not so well done? So it is Exhibit A about you as a lawyer. Is it going to reflect well on you? So if you're going to write something, make sure it's good. Or if you're going to give a speech, make sure you do it well and that you come across well. I think those are probably the things I would say.
Well, that's very helpful. So I think we're coming to the end of our oral history interview. I'd like to close with maybe just a couple observations. I met Doak in 1998 at the ITA when I was, a nobody mid-level associate at Vincent & Elkins in Houston doing, his first international arbitration cases. And what struck me about Doak is he was already a very accomplished lawyer, had written great articles, had a phenomenal career, but yet he was so kind and gracious and generous to this young kid that he just met at the ITA. And that set Doak apart, in my view. He was incredibly kind and generous with his time. The second thing I'd like to say is, I think there are probably a lot of people who would like to be Doak Bishop. However,
be careful what you wish for.
They have no idea how much work it takes to be Doak Bishop. In my practice, I've had the great privilege of getting a glimpse of what it takes to be Doak Bishop. No one is more curious, more well-read, and most of all, hardworking than Doak Bishop. The hours that Doak has put in over the years, reading, writing, thinking, simply cannot be measured. But for the fruit of those hours, the fruit they bore, we who have witnessed your practice of the art of international arbitration will always be very grateful. Thank you very much, Doak. It's an honor and a privilege to have interviewed you.
Thank you, Tom. It's a pleasure.